This is Session 2, Patent Office Cohorts.
Good morning, everyone. I'm Guangya Liu, a lecturing fellow at Duke Law School. I have been with Duke Law School since 2011. I teach empirical research methods in law. Our next session will feature an empirical paper, Patent Office Cohorts by Professor Michael Frakes at Northwestern Law School and Professor Melissa Wasserman at the University of Illinois College of Law. Professor Michael Frakes is an associate professor at Northwestern University. He previously worked at Cornell Law School. He is interested in health law and innovation policy. Professor Wasserman's research focuses on the institutional design of innovation policy with a particular emphasis on patent law and administrative law. Her work has appeared in many law review journals, including Stanford Law Review, Vanderbilt Law Review, Texas Law Review, Duke Law Journal, Review of Economics and Statistics, and Journal of Empirical Legal Studies. Our discussant, Tejas Narechania, for this session, clerks for Justice Breyer, and will be assistant professor at UC Berkeley Law School. This paper is really interesting. The concept of cohort is a very powerful one. Basically, your early experiences shapes who you are, what you do, how you behave, and how you will behave in later life. Since it was first brought up by the sociologist Glenn Elder, this concept has been studied very extensively in many disciplines, including sociology, psychology, medicine, law, political science, and etc. Typically, there are two approaches conducting empirical research. Some researchers would start out with a very unique data set, and they would try to find what's interesting about the data set and start out their research question that way. Another approach will be you start out an interesting question, and then you try to identify and even collect your own data, and you encounter a lot of challenges as well. So there are advantages and disadvantages on both approaches. So very rarely you would start out with a very interesting research question, and then you have an ideal data set that would answer your research question. And this paper is a typical example of that, and I very much look forward to hearing more about this paper. So the stage is all yours.
Yeah, thank you very much for that introduction. Today I'm going to be talking about an article that's really part of a larger research project that's examined distortions in the U.S. Patent and Trademark Office's decision-making. And the article today, as it's already been highlighted, is going to empirically examine whether the year a patent examiner was hired has a lasting effect on her granting proclivities. And the article is co-authored with Michael Frakes, who's going to join me in for a Q&A. Okay, so what's the motivation behind this article and the larger research project more generally? There is a lot of concern, right, that the USPTO is allowing too many invalid patents. And the literature has chronicled the series of harms that are associated with invalid patents. At the most basic level, right, it's the concern that invalid patents have the ability to impose the costs of the patent system on society, super competitive pricing and diminished access, but they don't give us any of the commensurate innovative benefit, right? If we're allowing patents on things that aren't new, we didn't need that patent to induce that invention to begin with. But invalid patents could also cause concern for follow-on innovation to the extent innovation builds on previous innovation. And more recently, there's a lot of concern that they're being utilized from non-practicing entities, right, to extract rents from innovators. There's also a wide belief that the agency's decision to grant your patent is a large function of which examiner your application happens to be randomly assigned, right? There's concern about inconsistency of patentability determinations across examiners. And this inconsistency has its own range of concerns, including, I think it implicates quality, right? We're concerned about quality, but also equity concerns, right? We'd probably like to design a system that's going to treat similar applicants in similar ways. So despite the fact that we've had the quality of the patent system be really central to the health of the patent system, there's actually little compelling empirical evidence that explains what features of the patent system drive an examiner's decision to grant outside the merit of the invention. And then as a result, we had policymakers who are trying to bring more consistency to PTO decision-making or increase patent quality, largely without understanding what may be the root sort of causes of its dysfunction. So what we're trying to do in this article, and actually in our larger research agenda, is to begin to rectify this deficiency and start to provide some compelling evidence that there are particular features that may influence the decision-making of the PTO. And so Michael and I have written a series of articles that have sort of gotten to this particular question that have examined the fee structure of the agency and how that creates a possible incentive for the agency to grant patents, the inability of the PTO to finally reject an application, that could also create an incentive for a resourced PTO to issue invalid patents. Most recently, before this piece, was a piece where we looked at time allocations. It's actually forthcoming now in the Review of Economics and Statistics that looked at that examiners are not given enough time, right, to do a good job, and this may allow them, or may be causing them to allow marginal patents. And then the piece that I'm talking about today, Patent Office Cohorts, again, is going to examine whether the year you're hired at the PTO has some explanatory effect of what your grant rate is throughout your tenure at the agency. So just very quickly, a little background about the examination process, right? If you want a patent, you're going to file an application at the PTO. It's going to come in. They're going to do a cursory review to figure out what technology field that's associated with and use that to route it to an art unit, which is an administrative unit in the agency of anywhere between 10 to 20 patent examiners that review applications in the same technological field. Once it arrives at an art unit, the supervisor then generally randomly assigns that application to someone within that art unit. And when it comes up on the examiner's queue, she's going to conduct a prior art search and use that to help assess the patentability of the claims, either allowing or rejecting them. So what's the theory behind cohort effects? That's why would we think that the year an examiner is hired by the agency has any sort of predictive effect on granting proclivities? Well, so I should start by just mentioning that patent examiners operate in a substantial amount of discretion in deciding whether a patent should be granted. And there is a fairly large literature, right, that suggests that early moments in your employment are really important to figure out how workers develop their practice styles or sort of operate and shape their bounds of discretion. So we just simply begin by hypothesizing that patent examiners are particularly susceptible during their first year of the patent office, and that the initial conditions they face at that time are going to have a persistent effect on the examiner's granting behavior throughout the course of their career, right? And that leads to our first hypothesis that says, all else being equal, the year a patent examiner is hired by the agency will impact the grant rate she follows throughout the course of her tenure. Now, our prediction is based on the initial conditions at the agency. So one may think as the conditions of the agency change, right, the cohort effects may also change. They're going to depend on what those initial conditions are. And we think one of the really most important initial conditions is what we characterize as the patent office's allowance culture. And so we define this as simply how much emphasis the agency is putting on at one particular point in time of allowing versus denying patents, right? Now, of course, measuring an allowance culture, any sort of culture of an agency, is inherently difficult. So we're going to use a proxy, and we utilize something called the Quality Assurance Program, which is really, you can think of as if the examiner allows a patent, it's how likely that decision is going to be reviewed from another person, and how stringently it's going to be reviewed by someone else. And so we think the Quality Allowance Program is a good proxy for a couple of reasons. One, the reports that come out of the Quality Assurance Program do factor into examiners' decisions to get promoted, so we think it has a strong effect on their behavior. And two, it's within the sort of discretion of agency heads at the PTO how they run the Quality Assurance Program. So what we envision is like you have a change in a director that comes in, and they may feel that the approach of how you apply the patentability standards should be slightly different, and so they're going to use the quality assurance program in part to effectuate that. So if they come in and say the PTO is allowing too many low-quality patents, they may choose to strengthen the quality assurance program, sending a signal to examiners that the Patent Office may value rejections more than it did previously, or alternatively, if the director comes in and believes that the agency is erroneously rejecting too many valid patents, right, they may weaken the quality assurance program to correct what they perceive as an overly restrictive granting culture at the agency at that time. Now, utilizing this approach, we map out really 3 different distinct regimes of allowance culture of the agency. So in the 1990s, we say they have a more permissive granting regime, and the mid to late 2000s, when Tejas comes over, it becomes a more restrictive granting culture, and then in 2010 through 12, when Capos comes back, it's a slightly more permissive granting regime again. Now, granted, we are not normatively staking out which one of these regimes we think is better. We're simply stating that in 2010, if you're going to get hired, it's going to be a more permissive granting culture than if you had got hired like in the mid-2000s. And finally, I should note, why we use the quality assurance program to map these out, we conducted a whole series of interviews with examiners and patent practitioners and supervisors and previous high-ranking sort of officials and looked at congressional reports, et cetera, to verify our sort of 3 allowance culture regimes that we've come up with. So that leads us to our second hypothesis, right, that patent examiners hired during a time period when the agency had a more permissive allowance culture is going to have a higher grade rate throughout their careers, all else being equal, if you were hired during a time period where they had a more restrictive allowance culture. So finally, we also believe that the new hire training patent examiners receive may affect their granting proclivities. That is, we think the longer you are as a new hire, you're subjected to formal, centralized training at the agency, the more likely you're going to be indoctrinated into the agency's culture at that time. And the nice thing for us is during our period of study, there was a nice natural experiment where the PTO completely changed their new hiring program. Prior to 2006, new hires were really trained under like an apprenticeship program. They get about 2 weeks of formalized training before they were put off to their art unit, where they got informal training from supervisors. Then in 2006, the PTO rolled out for the first time 8-month centralized university-style training, right, where you could get about up to 8 months of formal training before you were completely on your own in an art unit, where you got additional informal training by your supervisors. The nice thing is that in 2006, half the examiners got the old training and half got the new training. And whether you were put into one group or the other had to do with the technology that you reviewed. And since we can control for technology effects, it's largely like a random assignment. And so that leads us to our third hypothesis, as I already stated, right? The longer amount of time a new patent examiners receive formal training, the more likely they're going to reflect the allowance or be indoctrinated to the allowance culture of the agency at that time. Okay, so methodology, what did we use? We used a rich fixed effects design. So we wanted to estimate the relationship between the grant rate and the year an examiner was hired, right? And so we're going to have to control for anything else that we can think of that's going to affect the grant rate of that application. So the year the application was disposed, the experience of the examiner, the GS level, because that affects how much time you're given to review an application, the technology, as I noticed, some technologies have higher grant rates than others, and the maximum number of years a relevant examiner spent. So it's like tenure effect, right? You may just be a very different sort of person if you elect to stay at the PTO for a short time versus a long time. And this was a big data collection effort, right, because we're going to need enough information and data spanning a long enough time that we can decouple a cohort effect from all those other things, right, that I just listed. And so we used the PAIR database that's public available, and we had the help of the National Supercomputing Group at Illinois in order to pull information off of 1.4 million utility patent applications from 2010 through 2012, and we got information about the examiner associated with it, whether it ultimately issued to a patent, amongst other information. We also need information from the PTO, like what the GS level was of an examiner, whether they had the new or the old training, when they were hired. And so we had a whole series of FOIA requests that we've done with the PTO to get the additional information we needed. And then we match by examiner name across all these different databases, and we end up with roughly about 9,000 unique individual patent examiners. So let's get to the results. That is, do we see cohort effects, and do they follow the sort of predicted patterns? So this graph is a relationship between the grant rate and the year the examiner is hired, while controlling for a number of variables discussed in this previous slide, right? And so just to be clear, right, this is not, for example, the mean grant rate of the agency in 2005, right? What this point is the mean grant rate of examiners that were hired in 2005 throughout the course of their tenure at the PTO. So these, you can interpret these sort of coefficients that I'm showing here as a trend in the inherent grant rate across different cohorts of examiners based on the year that they were hired. Now, we've also referenced out the 1993 cohorts to 0, so everything can be interpreted in relationship to this 1993 cohort. So if there was no cohort effects, what we'd expect is this would just be a flat line, right? All the difference would be controlled for those other variables. But what we see is there is a substantial difference, suggesting that the year you're hired does have some sort of impact on what your grant rate would be. And it is fairly substantial. So, for example, if you were hired in 2007, right, your grant rate is about 11 percentage points or 16% lower than if you had been hired in 1993 over time, which is a pretty big difference. And remember, we controlled for those whole slew of variables, so this isn't explained, for example, that the PTO may have different hiring preferences in certain technologies over time. So in 2005, if they hired a lot, let's say in software or business methods, what have historically had a lower grant rate, that's not what we're picking up here, because we're controlling for technology effects. The second thing I want to note is that these findings are very much consistent with our second hypothesis. And in the 1990s, we said we had a permissive granting culture, so it seems like examiners are having more permissive grant rate over their tenure. And then in the mid to late 2000s, when a more restrictive regime, if you were hired during that time, your grant rate dropped, right? And in 2010 through 12, when you had a more permissive regime, then we saw your sort of grant rate go back up. So I want to be clear. What we think of is these people, if you're hired in 2005, that you start at a lower granting pathway and stay on that, even in comparison to one of these more permissive regimes at the same date and time. So let me explain that or show that a little bit clearer with this slide. Or this figure. So in this figure, what we're doing is we take the 1993 cohort and we show you what their grant rates and how they change on a year-to-year basis over time, controlling for all of those things, right? And this is what this blue triangle line demonstrates. And what you see here, right, is through this 1993 cohorts is that their grant rate does begin to drop in the mid to late 2000s when a more restrictive granting culture comes in. But it doesn't drop necessarily as much as we would have thought if they hadn't started in this more permissive granting regime to start. And we demonstrate that by also showing you what the cohorts are of the mid-2000s, right? These are people that started in the more restrictive regime. Notice their grant rates start and stay below that of the 1993 cohort. And then finally, we wanted to also show you the information or the figure regarding our training findings, right? So this figure is the same as the first figure that I showed you that plots the relationship between the grant rate and the year the examiner was hired, controlling for all those variables while breaking out the training effect, right? So here what we have on this side is the 2006 cohort only with the 2-week of formal training. Here's the 2006 cohort with the 8-month of formal training. Remember, and our hypothesis was if you had longer formalized training, you're going to be indoctrinated into the culture more at that time. 2006 was a restrictive granting culture, so we would expect the people with the longer training to have a lower grant rate, and that's what we see, right? And then in 2007, everyone got that 8-month centralized training, and you see that the grant rate goes down even more. So hopefully, what we've demonstrated up to this point is some evidence suggesting that the initial conditions do matter and that there's some learning stickiness over time, right? What the initial conditions at the agency affect patent examiners, how they develop their granting sort of style, and then it sort of stays with them over time. So we think this has a number of interesting policy implications, right? From patent policy, it's interesting to think of that if you're an agency head and you're trying to bring consistency to patentability determinations, or you're trying to effectuate some sort of change, right, in the examination behavior, it might be helpful to take into account cohort dynamics, right? You may need to tailor your intervention somewhat by what the different cohorts are that you're working with. Another suggestion is there's this famous line that there's as many patent offices as there are patent examiners, right? And we think that may just oversimplify the matters, right? A lot of the inter-examiner disparity is also due to the cohort effect, right? What year you actually ended up being hired on. Within the administrative state, we think it's interesting because I think at the most basic level, right, what do cohort effects do? They raise the cost of changing policy today, right, and in the future. Right? And so you can think of cohort effects as like this another tool that agencies can use, arguably, to entrench policy over time, right? Like the famous midnight regulations. But there are, I think, distinct differences between cohort effects and other types of ways that you entrench policy over time, including they're much less transparent, that just give them sort of another tool that we can be thinking about. And then finally, I think it also gives us some insight into the effectiveness of agency monitors, right? To the extent you're entrenching policy over time, right, you're entrenching it against future agencies, but other sort of principles like Congress, right? And whether you think this is a good thing or a bad thing is going to depend on what your normative take is on agency autonomy versus accountability.
Just give me a second. Oh, do you want me to? Is it better?
No.
if I stand?
I just want to see the slides.
So we can see your slide.
Oh, well, the slides are actually pretty spare. So I just want to start by saying thank you and echo all the calls for thank yous to Duke Law School and to the Journal for inviting me, to Melissa for proposing the symposium and inviting me, and to Melissa and Michael for such a fun, interesting, and really rich paper. I really enjoyed reading it and had so many thoughts that it was hard to organize and put together exactly what a narrow and cohesive set of things that I wanted to say. So I hope that I've done that. I also especially want to thank Seth for putting me on not only the right flight, but in exactly the right seat. On my flight down, it turns out the gentleman sitting next to me was a patent examiner. Not only was he a patent examiner, he was I can't make this up, he was a patent examiner from 05 to 06, and then he left to go pursue an advanced degree, and then he came back in 12. And so I had all sorts of questions for him. And I will allude to John the patent examiner throughout my comments.
Do you know his last name? I can look him up.
Yeah.
I have his card, John Bird. Okay, so as Melissa mentioned, the paper theorizes this idea of cohort effects, which I take as a sort of short definition as sort of a model for explaining the behavior of agency actors by reference to their hiring class. And the paper, as Melissa explains, there's a huge data collection and analysis project behind this to test this. My comments are going to focus mostly on the conclusions and the implications of the findings. I'm going to take the empirical findings largely as they come and leave methods-related questions to the Q&A, but with one exception. And that's because the one exception connects to one of the broader themes that I'm really interested in, which is this idea of an agency's culture, right? What is an agency's culture? How do you define it? What are the different aspects of an agency culture? And in particular, one thing that I was struck by in the paper is that we're measuring cohort on an annual basis, but there are only 3 relevant cultures. And so the methods-related question, the specific methods-related question I have is, what do we learn from the individual years that we would lose if we grouped them into the 3 salient cultures, right? So there are 3 groups. We have the 90s cohort, the mid-2000s cohort, and the post-2010 cohort. But we don't think of cohort that way. We think of those as 3 cultures in which there are several cohorts. And I want to know if there's something special about 94 versus 93, or 06 versus 07. I mean, 06, 07, there's a case to be made that the rollout of the training program makes them special. But that's more of a case, I think, to do a particular type of natural experiment than it is for us to really think of them as distinct, otherwise think of them as distinct. And so the broader theme, the broader question is, what's the relationship between a cohort and a culture? Should we measure culture annually, or do we measure it in greater time lengths? So the second question, I think this relates to that, is if there are only 3 cultures, there are cultural shifts between them. And what causes those cultural shifts? And Melissa, you alluded to in your opening presentation using the quality assurance procedures as a proxy. But the question I have about that as a proxy is, do you think that the quality assurance procedures drive cultural change, or do you think they reflect some other source of cultural change? There's some support in the paper for the former view, that the quality assurance measures actually drive cultural change. Boudins, who I think is the president of the Patent Examiners Union, says that the quality initiatives created an environment where examiners were fearful of allowing applications. And that would suggest that these changes actually drive a culture or drive an attitude among the examiners' corps. But I'm more persuaded, and I think this is probably where you come out, though I'm not 100% sure, that the latter view is the better view, that there's something else, whether it's the director or the president or a change in law, there's something else that comes in, and the quality assurance procedures are a reflection of that something else. So that's this, right? So the evidence of the shift is in 2002 to 2003. But the quality initiatives, as far as I understand them, don't come online until 2004. And if that's right, then I don't think we can think that the quality initiatives themselves drive the cultural change. That there's something else, there's something that predates the institution of these new procedures, something that anticipates these training systems, that's suggestive of the force of culture. So that leads me to my third question about culture. And the third question is, what drives that change in agency culture? And I think this, to me, is the biggest question. How do we identify that source of agency culture? Lots of hypotheses. So one is that it's law. Right? So we could think that changes in Section 101 jurisprudence, for example, affects the entire granting culture, that as examiner corps see shifts in law, in obviousness doctrine, or in subject matter eligibility doctrine, that the entire examination process will move towards a more restrictive or a more permissive granting culture. And that could happen either on 101 basis alone, for example. So you could test maybe our applications being rejected on 101 grounds as the law moves in that direction. But I don't think that explicit tie is necessary. It could just be that a law's shift in general towards a more permissive or a more restrictive culture is enough to shift the entire regime. The other alternative, if not law, is politics, right? It could be that the president sets the culture of the agency. This is what Professor Benjamin was talking about earlier, where the NLRB, a perfect predictor of the NLRB's decision is the politics of power. Who is in power decides the outcome. And you might imagine the same is true here in patent. Now, one common objection is that there's no politics in patent. I'm not persuaded that that's the case. The obvious response is the SG in the reverse payment Hatch-Waxman antitrust suits. The SG's position has been correlated by some to the president party, the power of the party of the president in power, So, maybe there's some questions to whether politics does or doesn't play a role, but if it does, let's assume that it does. I think this is a closer fit. The administration rolled over the beginning of 2001, and the change happened in 2002. It's closer than, or I think has more explanatory force than thinking that the training regime itself is what changed the culture of the agency. The last option is that there's some other policy change, so that there's something that's neither political nor legal, but rather just an attitude towards patent in general. And I think this is actually the best fit, right? The policy changes that are announced in 2002 aren't implemented until 2004. And I think it's just the rhetoric of should we grant or should we not grant is enough to create whatever the culture is that moves the examiner's attitudes in the right direction. These policy choices also might explain some of the other markers. So for example, rolling out the detailed training program in 06 for some technology classes prior than others. If you can imagine that there's a particular policy preference to not grant software or hardware-related patents, then you might prioritize rolling out these types of quality assurances to those before others. The other thing that this tells us is we're able to discern what kinds of external stimuli are more salient. Because the rhetoric had such a strong effect in 2002, but the drop-off when the quality assurance programs come on in 04 isn't as great, might suggest that it's not the training that actually moves the needle, but just something else in the agency that actually moves examiners in one direction or another. Okay. So this is my last question on culture is, where does culture and the individual styles it produces have the most impact? Are the effects stronger in certain technology classes? Is discretion greater in certain technology classes? So if discretion is greater, we might expect the effect to be stronger. This might be true in software patents, for example, and I wonder whether or not that actually happens. Another idea might be, does this only matter on the margins? So imagine that some patents are easy. They're easy grants or they're easy denies, but some are harder. Does an examiner's priors affect whether or not they're more willing to grant that particular application? Maybe a way to test that is the number of office actions. More office actions is an indicator of a harder patent. Is the correlation with the cohort effect stronger in such applications? And then the last sort of set of questions I have on culture and style is about personnel. And this is where John, the patent examiner, comes in. So what happens when styles clash? So John was telling me about the second time he was there, he clashed a lot with his boss, who said, I know that this isn't grant worthy. I know there's some prior art out there. There must be something. Go back, go do it again, go find it. And he left. And so I wonder whether or not those that were hired in a previous cohort and then rise to a supervisory position, what effect does that have on cohort effects going forward? Likewise, if I'm an examiner and I haven't climbed the ranks, only been there 1 or 2 years, and the style changes, am I more likely to leave because my priors no longer fit with the agency's culture? And is there greater attrition during these periods of shift? So the set of style questions now leads me to the second set of things I want to talk about, which was the question of style and where else it comes up. I was really intrigued at the end of the paper where you talked about this might show up elsewhere in the administrative state and how should we think about this. So I have just a couple quick ideas about where else I think this might pop up, but I'd be really interested in how else you're thinking about this. So one idea is in antitrust. So antitrust and merger review in particular is a place I think where FTC staff, for example, have a fair amount of discretion in how they at least go about this in the first round. And the same set of questions of how an agency's culture would affect how they exercise that discretion comes about. And what the source of that culture is. Is it a legal source? As the law has moved towards a more permissive view of vertical restraints, have FTC examiners or merger reviewers been more willing to let vertical mergers go through? There's strong evidence that politics is important in antitrust review. There's also strong evidence that policy is really important, as it varies from different industry classes. Another question is on prosecutorial discretion. So right now, I think the Obama administration has issued guidance to its prosecutors that says don't enforce or de-emphasizes certain marijuana-related crimes. What's the staying power for that? How will prosecutors view that were hired now, how will AUSAs view those crimes going forward? And then the second set of places outside the administrative state that might be interesting to look at is in the judiciary itself. So, what do these learned behavior models, these cohort effects, have for questions like Twombly, where judges that were on the bench before Twombly were decided, how do they compare to judges that were confirmed after Twombly? And likewise for Booker. Do earlier judges sentence in range more? So that's all I have. Thank you very much for a really interesting and rich paper, and I'm looking forward to your responses.
Thank you. Those are great comments. Let me just hit a couple things and then I'll turn it over to Mike. So we definitely were sort of thinking of more of a lot of the change may be director related, right? Who's coming in? And I think it's a great question about what's driving that, right? Because we do tend to think that politics does not play as much role to be anti or pro, perhaps, patents. But the sense that we got is when Tejas came in, it was this idea that they're granting too many and we really need to be more restrictive. And I thought when Capos came in, the email was, we're trying to address the culture of rejection, right? And then I think what we were envisioning was the quality assurance program was the mechanism or one mechanism by which the director may have been able to influence examiners. And there's clearly other ways that I think are going on that could be much less informal, right, through top-down supervision. But the hard part would be we were trying to come up with something that we could measure across the entire time, so it didn't seem, like that just gave it a little bit more structure. I think you're completely right about the supervisors. We've been told over and over and over again by examiners their SPs have a huge effect on what they're doing, right? And there's some things that we've sort of thought about for rolling that out and trying to look at like a SPI effect on examiner behavior. Do you want to add?
Right, and we even submitted some FOIA requests to get some information on SPs because we love submitting FOIA requests and collecting stuff. And from that perspective, you think of kind of what we're doing is also, just exploring in these situations that are like high-skilled positions like this, just how preferences are developed. You can just open up a bunch of different questions at that point. And we sort of started with sort of thinking about like this sort of early training and enduring effects that could come from that. But if we started thinking about interactions among peers and also among supervisors, just a bunch of different additional analyses. So I think that we completely agree with you, and we're encouraged that you thought that those are interesting questions. So it'll be helpful for us to proceed. In terms of the question why, why approach things by year, I would say one way to sort of think about that is we sort of approach our hypothesis here from two perspectives. One is we just generally hypothesize that there will be cohort dynamics, cohort effects. And so, there are the ideas, as Melissa said, that would sort of lead to, if we thought there were no cohort effects at all, that you would sort of just predict a flat line on that first. And so that doing it year by year just helps us assess just this general, just make a general inference that, that there is something to the idea that initial hiring conditions matter before getting to the question about specifically how that plays out. And there's some history behind us wanting to ask that general question, and it has to do with how this paper relates to the prior paper. I'm happy to we can chat offline about that, where we're challenging prior research by Mark Limley and Bob and Sampit in a particular way. And so one thing that we thought was missing from an earlier investigation they did into what's the relationship between characteristics of examiners and their grant rates. One thing we thought was missing from some of their discussion was just the possibility for cohort effects of this nature. And so we just wanted to explore that as just a general missing, observation. And then having gone through that, we wanted to say, okay, we saw this pattern, and is it consistent with just in a specific manner with our what we would sort of predict how that pattern would look like. And that, admittedly, yes, we don't have that on a year-by-year. Those, as a theoretical matter, we don't have sort of year-by-year predictions about how it would play out. It's more grouped into, in sort of 3 groups and arguably 5 groups, depending on how we break out the 2006. So.
Does the audience have any questions?
So I know that in a previous paper you did really interesting work finding that as examiners get promoted, they get less time to review patents, and that affects how often they grant patents. And I'm wondering if either in that paper or in a future paper you're going to combine that with this to see who gets promoted in the first place. That is to say, have you thought about looking at whether or not different cohorts they recognize, oh, okay, in order to get promoted, I guess I better start being grant happy or grant unhappy. And so different cohorts have different rates of promotion depending on who their supervisors are. I'm assuming you can tease that out of your data. Maybe it's already in the previous paper, or maybe it's in the next paper. But
well, I think something is in the previous paper. We just didn't break it down, I think, in the cohort level that you mentioned. So this previous paper, we're trying to ask the question about, do you start to grant more permissively as you get less time to review applications? And the idea is there's a presumption that these things are valid when they come in. And it's the onus is on you to sort of find basis by which to reject. You don't have enough time to do so. You may be in a position where you're going to have to sort of grant more permissively. We can test this by sort of looking at the fact that, as you get, promoted, you have less time to review applications. And so we've got information on when people are promoted and what levels they're promoted to. And so without getting into the nitty-gritty there, we sort of use it as a way to sort of test this general question about what's the relationship between the time that you have and the amount of, and your granting proclivities. And with that analysis, Stuart, I would just say that we kind of treat the promotion events as exogenous there. But we try to make ourselves feel a little bit better by asking. So we did some preliminary analysis. What is sort of predicting the speed by which you get promoted through the patent office? And because maybe we would have been concerned in that paper if it's just the really high granting people are the ones that are getting sort of promoted quickly. And encouragingly, we actually didn't find that. It was either kind of flat or maybe slightly in the other direction. So that maybe what's being valued is actually a little bit more of a tough approach to granting, but we didn't. Yeah.
But we did look at that. I'm just thinking whether it's worth looking at the code.
Yeah. So we didn't do that. We didn't go take it to the next level you suggested.
Yeah,
which is
and that'd be interesting.
I think that would be really interesting because that would also, I think, get to the question of. Sorry, I don't know if I was. I just realized it would help tease out as well. Some of Tejas's questions regarding exactly what's motivating. Differences in cohorts, because I think if it is more top-down and coming from the director, then you might see promotion effects as well.
Yeah.
So that just may be a way of thinking about it.
That's interesting.
This is another great project, and I like the cohort theory. It reminds me of what one of my physics professors used to say was that the definition of the new physics is all the physics developed since you were a graduate student. And so that you can imagine maybe the same thing is going on here. I guess a couple of questions, just trying to think of the policy significance of this. I'd be interested in knowing whether we could expect a kind of differential impact on different technologies here for at least one of two reasons. One, you might imagine there's more turnover in terms of examiners for different technologies, and then you could think that means those are going to be more responsive to changes in the patent office over time. And the second, you could wonder whether there's some stickiness if we think, say, in the biotech area, the examiners generally have PhDs are more sophisticated. Does that mean they're somewhat, less affected by this sort of training or cohort effect than others? So I think that there's just even more interesting stuff, I think.
Yeah, I think that's like a great question, because one of the things we think about is I think it's like how moldable are you as a new hire examiner, right? And the prior work experience, like we tried to get experience like, did you work as a patent or as a patent attorney before you went, or as a patent agent, right? But I also think the PhD can stand as a proxy. We just got education information, so we want to go and run and look at that as well.
to go back to even an earlier paper, the paper on money and maintenance fees.
Yes.
So have you corrected for cohort effects, and did you correct for cohort effects then? Because I wonder whether the amount of money that the patent office has actually affects the way that the examiners think about it, and maybe you'd see something if you went back to that paper.
Yeah, I mean, we haven't done it yet, and we certainly have thought of some ways to sort of connect. We did some stuff here to sort of try to reconcile the two stories to some extent. And so it's like what here we're seeing in the mid-2000s is sort of, and this is not necessarily getting at your question, but a more restrictive sort of stance. And but they're connected to the other paper. Well, there could be a financial consequence associated with that. And so and we always sort of said in the other paper that when they're taking a financial hit, that it may sort of lead them an incentive to grant more on the margin. We're always careful to say, more on the margin relative to what they would otherwise be doing. And so I guess if you're taking the two pieces together, I would say that, what we see is actually the grant rates are going down in the mid-2000s, but maybe not by as much as they otherwise would have, absent some of the financial implications. So this is the way that we've sort of thought about the two papers together so far, but I think we've sort of sketched out some ways to.
Financial effects also might affect the culture. So.
Yeah.
Right. And so,
The other question I had was about search strategies. Yes. So during this time period, the ability to search online really changed. So you have examiners who, it's not culturally that they're different, it's that they're using their old search strategies, and another group is using different search strategies, then they get optimized, and that might produce a difference. So do you know what kind of search strategies?
We haven't tracked that, but we need.
No, I mean, but one thing that we're at least accounting for with this exercise is just that year by year, granting tendencies can change. Just year by year patterns of whatever we're looking at can change, and that's not. And we're not.
We have some technology here.
And we could also, and so we're basically trying to sort of wash that under the rug, sweep that under the rug with these year fixed effects that we have in there. And so we're kind of saying that we acknowledge that these other things could be happening, but given that could take on some completely flexible, unknown pattern, I still want to try to hone in on just this cohort dynamic that I'm sort of talking about.
The search technique that you learn when you come in is sticky, and you're continuing to use that. And then new people come in and they have a different search technique that they're using. That could also affect the grant rate.
Right. I mean,
if you're a quicker searcher.
I look at that as, and I think of that as more maybe an initial condition type of thing that's changing as well. Yeah. So maybe look at that, figure out, and if we can get some better information as far as when that changed, and then we could possibly make some predictions on that too, especially if we have some variation in technology when they adopt. That might give us another sort of thing to test, which would be interesting.
In the back.
I just had a question about the changes to the count procedure for examiners and whether you took that into account at all when you were looking at the culture.
Yeah, so a lot of the most recent things happen just on the tail end, right? With the count changes, and I actually think that's also one of the ways it's reflecting, right? How Kapos wanted to sort of change the culture would be through the count system sort of changes as well, to be give them more time and make sort of better sort of decisions. So. It's something that occurs at the sort of tail end. I don't think it would have any sort of dramatic effect on some of the predictions with respect to cohorts, but we know what's going on there at the end.
Hi, I'm Robert. I'm 3L here at Duke. Real quick question just about maybe zooming out to the practical effects for a patent prosecutor.
Mm-hmm.
Between this paper with this explanatory variable that looks pretty predictive as far as I can tell, and the previous papers y'all have run,
mm-hmm.
Are you seeing a possibility that this could be a model with a pretty strong, with multiple explanatory variables and a pretty strong correlation coefficient, that a patent prosecutor could have this data maybe before he sends it in, and then after he sends it in and he sees the name, and then, 6 months down the road, 12 months down the road, and have a more concrete ideas?
Yeah, we've never done it. We've done some individual examiner sort of fixed effects stuff, but we have all the data, right? That if you gave us an examiner name, we could pull it up, tell you what their grant rate is over time, how things have sort of changed, right? That could give you some particular sort of guidance on that. And there are several sort of companies out there like Jurostat that are sort of in the game of doing this. And I think this is in part why sometimes we've had pushback with the PTO and data, right? Because this is like their worst case scenario. They don't really want, you know, somebody to get an examiner who they don't like and then try to push and get somebody else, right, that they think it might be better for. And there's definitely, you know, when we talk to attorneys, like there are even things we've heard, right, you get classified based on your first claim, and they have written claims in a certain way to try to get into a particular art unit and then cancel claim one, right, because they think this art unit's more grant happy, perhaps, than another art unit. And I don't, you know, it's just more lenient, I should say, than another art unit. So I think these things, you know, the data does change, you know, the sort of gamesmanship that can be played. And Michael and I, our work has really focused on agency incentives and individual examiners incentives. We haven't thought as much on the applicant side, right? But there's definitely some things that we could start thinking about doing and utilizing our data to look at.
Especially, as, I would just say, especially as I just to say that we also we've made our data publicly available as well, but not that I would know that. Would the litigators know to go to the Review of Economics and Statistics website to find this? I don't know. Yeah. Or the prosecutors, sorry. Yeah.
I'm sorry I hadn't time to read your paper, but I had a question and a follow-up observation. When you say there are 300,000 applications per year, is how many patents are granted per year out of that? What is the between these periods? What's the grant rate in quantitative terms?
Right, and I would just say it's a hard question to answer because it's not, because it's hard to have a final rejection at the patent office, right? So I would say, so I have to say that to qualify, our numerator here would be the number of allowances, and the denominator would be number of disposals. And the way, generally it's 70% with some of the data that we have, but that would be a disposal would be, either it's allowed or it's abandoned, but actually an RCE would not count as a disposal the way we're sort of treating it, but a continuation would. So it's, these differences I don't think matter for what we're doing, but how we're kind of approaching things, it would be a 70% grant rate.
70% grant, so that's a lot. Okay, so it strikes me that historically, there was a great debate between countries that had no examination system at all. They had a registration system and then the examination system. And of course, I guess the philosophy of the registration system is you can't trust the examiners, they can be bribed, let the market decide. And the philosophy of the examination system is, well, we don't want to put that much strain on the market. So that it seems to me that what's evolved here is not an examination system at all. It's a modified examination system midway between the old registration system. You get some preliminary, you get something that they call examination, but basically if you're issuing 70% of 300,000 patents, you're flooding the market with patents and you're letting the market decide. So it's a third model. It's a third model that combines the two. And I think we need to start thinking about that, whether we really want that model or not.
Right.
Yeah, the one thing I'd add to that is that, there is, even if they're granting at a high rate, there is some narrowing possibly of like claims that are going on.
Follow up on that. So, one of the arguments that could be made is that certain cultures in the patent office, and capitalists would have argued this, want to just narrow claims really quickly and grant that narrow component very quickly. So the grant rate tells you something about culture, but not necessarily whether it's permissive or not. It just tells you something regarding whether there's a desire to find some core of patentable material. So, I can say that Capos definitely was of the opinion that you want to do compact examination. If there's anything to be found, narrow it quickly and get it out.
Yeah.
But that's a very different thing than saying we just want to grant.
Right. And I think that's fair. I mean, like one thing that we've been trying to do to build on everything is what we've done right now is grant rate, allow or not, right? And I mean, historically with this particular field, right, we weren't even able to calculate the grant rate because we didn't know what the applications were. So we do feel like being able to do this is like a step forward. But it's not perfect, and we know that. And we've been trying, and we've submitted some proposals to get data on what you're talking about, where we're trying to figure out how much claim narrowing is our examiners doing, which would give us sort of we could repeat some of the things that we've done, and it's either going to be maybe not as concerning or more concerning, depending on how much narrowing and is this changing under different. So I think that's a great point.
Can I actually go back and say one more thing about Jerome's question, which I think is it's a big interest to Melissa and myself. The idea of registration system versus actually real scrutiny. It also sort of gets at not just like the PTO versus the markets and let the markets decide, but also the courts. Yeah. Because it's if you think about applying patentability standards, it's not just the PTO. We consider reserved for the courts. And this gets to Lemley's idea of sort of rational ignorance, and maybe we should just sort of have a little investment at the PTO and so on. So, and this is something we've actually confronted a little bit with our work. And in our prior paper, we were able to sort of do some exercises to be able to, without getting into the details, to assess where do we get the bigger bang for the buck by investing more at the patent office versus the courts. And we actually have some back of the envelope calculations suggest that actually we're under investing at the PTO level now. But Artie and I have had discussion with Melissa as well that maybe PTAB is going to maybe change how we should think about that analysis. Yeah. We should update what we've done already.
But that's sort of, our sort of view is more upfront.
The student in the back have a question.
I was wondering what if your data took into account the allowance rates when someone was like a primary and then when they got upgraded to a SPE eventually, like as looking as a supervisor, whether their allowance rates went up? Because right now a lot of those examiners that were in the restrictive period are SPEs now. I know this is anecdotally, but my SPE was during the restrictive area and he has an 85% allowance rate. So it's kind of like, there's a lot of rebellion there, I guess. So I was wondering, if there's a change in that respect.
I'm just curious, and was that his art units 85% allowance rate, or was that
was
him?
His personal.
Yeah. There's probably, I'm curious how many, because one way to answer is generally you're not reviewing as much when you turn to be when you're actually a SPE, right? So I'm wondering how relevant that really is, and that's I would say that it's not one thing. We've tracked how your allowance patterns are changing as you move up. As you move up the grade levels and as you get partial signatory authority and full signatory authority. I don't think we've actually done.
We didn't have enough data for SPEs.
SPE. So, and then, we actually did look at, we saw the same pattern happen when you rose to GS15, but I'm not, is it the case at all?
There are multiple
There are different types of GS15, and so we just grouped them together. But we can do more on this, but we did see that when you go up to GS15, you get the same, go back to our last paper, you get a bump in allowance rate, and then over time there, it kind of goes back down, so yeah.
It seemed like it'd be interesting because, it's usually like a bargaining process with the SPEs, if the prosecutor's not very happy with the way the examiner's treating it, they're going to go to the SPE, and then they'll bring them into, the examiner interview, so.
That's interesting.
Yeah.
That's interesting.
Thank you all for a very interesting discussion. This concludes our second session. It's lunchtime.
Well,